Please be seated. Thank you. Let's go back on the record. Let the record reflect. Counsel for the state, counsel for the defense. The defendants are present. State, this was your motion, or you had a challenge. I'm assuming you are moving to exclude him.
I'm moving to exclude him completely, Judge, and I want to make the argument that, I don't know if you are a Jon Stewart fan. He signed off last night, and I didn't see it last night because I was getting ready for trial, but I saw it this morning, and his sign-off was, and I will say it less colorfully than Jon Stewart said, there is BS out there, is what he said, but he used the real words, and he said, when you smell it, you need to call somebody on it. And that's what this is. This man is part of the problem and not part of the solution for police officers. He is going around training officers to shoot first, and he'll come in and defend their conduct, that it's okay to shoot people in the back, it's okay to shoot unarmed people. And then he's also training investigators to let them have a couple days so they can get online and look up his stuff to figure out what you say to defend yourself in a proceeding. And he has never been qualified, and I understand he's been let into a lot of courts, but a lot of the criminal cases he's testified in, Judge, too, are secret grand jury proceedings. He's brought in to sort of whitewash when a police shoots somebody, to come in and explain in a secret grand jury, let me tell you about how this shooting was justified based on my research about why they shot him in the back, and then it comes out of the grand jury and no police officer is indicted as a result of his testimony, and no one gets to see what he's doing, and he's been doing it in secret in his criminal cases for a while now. This man should be stopped here in New Mexico. He is not qualified by training. This whole idea that there is nowhere in the world other than at his university and his program a police psychology degree that does not involve clinical psychology. All the other police psychologists and the degrees for police psychology are for giving clinical training to police officers. Finally, in New Mexico, we've got a rule. You can't come in here and say you're a psychologist unless you're licensed somewhere. He's licensed nowhere. He's licensed nowhere. And even though he's giving opinions on these studies, he's holding himself out as a police psychologist here, and I think it is wrong to allow him to testify based on education, which I think is deficient, and based on the self-serving research that he has done over and over again that does not have scientific standards that he complies with, and much worse, has this whole issue of confirmation bias. It is obvious he is biased in favor of the police just by the fact that most of his publications, and most of the ones that Mr. Robles went over except for one or two yesterday, are all published in police magazines, and that's not peer review. This is exactly like the experts that the tobacco industry developed to come in and say smoking doesn't cause cancer. This is exactly the same thing, Judge. And he's been going around the country doing the same thing, and I would ask the court to stop him here. If the court is not willing to, and I also, on the flip side, Judge, I also understand this is a preliminary hearing, and I understand the court can listen to evidence and disregard what it thinks is not believable. And if you are concerned about an appellate issue, I also understand that if you allow him to testify just to get through the prelim, my request would be that you limit him very strictly just to reaction time and his research on reaction time, and none of this hogwash about attention span, or the police officer can't remember what happened or what he's focused on, that all of that is just hogwash, as indicated by the psychologist who came up with the term inattentional blindness, says you just cannot use it in a real life setting or in a courtroom because it just is invalid, because you can't tell whether the police officer really didn't see it or is just saying he didn't see it. So that's my argument, Judge. Thanks.
Mr. Bregman, any comments?
Your Honor, just that I think that any criticisms of his work that was brought out is not specific to what he's going to testify to today. The work that the issues that he's going to testify today to, there was no criticism. I think that came out. I also don't know that calling this all a hogwash is just enough by argument. I haven't heard the evidence to support that this is all hogwash. To the contrary, the government said that a few people have criticized this. Just like everybody that does work, it's criticized. I also don't believe just because he trains police officers means that somehow he is biased or untruthful, just like other police officers that have come in here and will continue to come in here in this hearing and talk about training. Just because they are police officers doesn't mean they're biased about the training. So with all that said, I think this goes to weight, not admissibility.
Mr. Robles.
proffer was very narrow. I did not ask for the court to accept this witness as a witness or an expert in all of psychology. Again, it was a very narrow focus because the focus of his testimony is actually very narrow. I asked about human action and reaction. In the the cross-examination, you did not hear those words asked by the state because there wasn't any criticism of Dr. Lewinsky's studies on action and reaction. Again, we also asked Dr. Lewinsky, have there been any criticisms? And there were none. And I think that that's the most telling thing, that the focus of our inquiry is an area in which there has not been criticism. And again, we're focused on two studies, and I identified them for the court, and if the court would like me to restate them, I will. Now, in the cross-examination, there was criticism of other studies. There was no criticism in the form of a question being asked about the studies that are being relied upon in this particular
And those studies go to the action-reaction
Yes.
time? Is that what you're talking about? Okay.
So it's action-reaction, and then there's this notion of inattentional blindness. That's not what we're going to ask this witness about. The one question that will be asked is essentially, how does stress affect the time it takes to make a decision? So our focus is ridiculously narrow. I have to say that I've crafted the examination to essentially talk about human factors, that is, how much time it takes to take certain actions. And from that, certain conclusions could be drawn. It's not going to be testimony about an officer's state of mind, what an officer does or does not remember. So this frontal assault on Dr. Lewinsky missed what we want this witness to testify about. And for that reason, Your Honor, there has been no evidence given to the court that challenges the reliability or the validity of the studies upon which his opinions will be given. And as a result, we would like the court to allow this witness to continue to testify about the foundations of his research, the two articles that we're going to talk about, explain what those articles mean, and then apply them to this case.
All right, thank you. Well, let me tell all of you that some of my concerns is, and I asked the witness to please try to separate the areas as much as possible, because I'm trying to determine which area of his testimony is certainly relevant to the case and will be helpful for me, being the trier of the fact as well. You all know the rule. I mean, do they have some sort of specialized knowledge or training, and would that information help the trier of fact in the case? That's basically the rule itself. My understanding here was that I think after Mr. Robles had initially spoke, that there were going to be 3 or 4 areas, and that was going to be officer perception, action, reaction time, and then the one of memory and legal force encounter. First of all, let me take the last one, the memory and legal force in encounters. I just listening, I think that's a little bit on the speculative side. I don't think that it would necessarily assist me in this case in making a decision when we're talking about memory. So I don't think that would be helpful. So I'm going to exclude that particular area, because I don't think it would be helpful to me in making a decision in this case. With respect to officer perception, again, I think that listening, that's one of high speculation, at least from what I garnered. And I'm going to exclude that one as well, because I don't feel it would assist me. What I do feel that is certainly relevant and that would assist me is the action-reaction time. As all of you know, one of the issues here is how long did it take for the defendants to make a determination based upon Mr. Boyd's actions to decide whether or not to shoot in this case. And I think if there's any testimony that helps guide me in making that determination as to how much time it takes to react under a stressful situation, that would certainly help me in making a decision. And I would ask that we keep it as narrow as possible to that particular area, because that's the area that I find that is the most relevant to helping me make a decision. Now, I know that the state brought out some other issues about the way the degree was obtained and an allegation of, perjury and all these, some other things. I take those as to the weight of his testimony, and that will certainly go to the credibility. And like I judge the credibility of all the witnesses in this case, I'll give it whatever merit I feel it merits. And that goes with all the witnesses as well. So with that,
I just ask for a simple clarification, if that's all right, Your Honor. One of the studies, the one that was not challenged, and again, I'm sort of taking the essence of it, the effect of stress on the time it takes to make a decision. So it is human factors, and I just wanted to be sure that in asking about human action and reaction and the time those, that it takes to do certain things, that's within the ambit of the court's ruling.
Mr. Robles, and I'm going to try to make it as clear as I can. From my perspective, I think what's relevant for me to understand is when an individual is in a stressful situation, what sort of effect does it have on the individual to make a determination or decision and then to act on that decision? That's what the court feels is relevant information.
Very well, Your Honor.
Okay, sir. If you want to, yes.
I just want to put on the record that Mr. Robles has acknowledged this is a human factors issue, and Mr. Lewinsky said that he has no training in human factors, none, 0, zip. But I understand the court's ruling, and I've got it. Thank you, Judge.
All right, thank you. You can go ahead and have your witness come back in, and if you would please advise him what I've ruled on, and try to keep your questioning to that area.
If you might.
Yes, sir.
Okay.